Good morning, everybody. Happy Super Friday. And I say Super Friday because it's been a fairly difficult week, but I am determined to end it on a high. So let's have a great day today and enjoy the courtroom drama, as they say. And speaking of courtroom drama, there's probably no better place to start than in Miami-Dade with Judge Glazer. Let's see what's going on.
Vou indicar o senhor para o programa TAP, que eles vão ajudar. Eu sinto muito pelo senhor ser indigente. Então, eu vou estipular a sua fiança na primeira acusação de tentativa de alterar a prova em 10 mil, posse ilegal de cocaína 10 mil e apetrechos para drogas de $5.000. Boa sorte, senhor.
You have to go to court for your arraignment on October 14th at 9 a.m., courtroom 47.
O senhor terá que comparecer judicialmente no Fórum da Justiça para fazer a sua primeira aparição em juízo. Essa audiência está agendada para o dia 14 de outubro de 2025, às 9 da manhã, sala de audiência. Your Honor, I'm sorry, you said 4A?
Courtroom 48, it's courtroom 47, Judge Stuzen.
47, ok. Sala de audiência 47, Juiz Justin.
Okay.
If you can let Mr. DeCeso know that I'm providing him with the Public Defender's Office phone number and his paperwork for his future court date.
Senhor, este então é o telefone da Defensoria Pública e tem informações da sua próxima audiência.
You can meet with a representative from the TAP program today.
E aí o senhor vai encontrar com o representante do programa TAP.
Have a nice day. Thank you, Madam Interpreter. You're excused.
Thank you, Honor. Have a great day.
Thank you. Next, Oscar Rodriguez on page 8. Is that Mr. Cooper's here for that case? I think so. Oh, it's busy. Good morning, Mr. Cooper. Are you here covering, you said, for Mr. Meyer?
Yes. Hi. Good morning, Judge. Pleasure to see Your Honor.
Good morning.
Cooper,
Always a pleasure.
Good morning, Judge. I'm Richard Cooper, of course. I'm standing in for Michael Meyer on behalf of Mr. Rodriguez.
Mr. Rodriguez, do you speak English? Thank you. You were arrested for operating a chop shop, grand theft, a third-degree felony, and possession of a vehicle with an altered identification. So your attorney is here, Mr. Cooper, or he's covering, I should say, for Mr. Meyer.
Correct, Judge.
You know, he has an open case, an open felony, and he has a fugitive hold from Lee County.
So you have a hold for F24 24683. There's a hold for you to see the division judge.
Judge, in this case, could we just issue standard bond on the new case, and then on the F24 case that'll be set for division?
Yeah, let me just review for probable cause.
Thank you, Judge. And then also, Judge, I didn't see him on the in-state extradition calendar.
Because he won't be until he's ready to go. So his bond has to be paid and he can't have the holds. As soon as he's technically released on his local charge, he's ready to go to the other county, either by posting a bond or having it closed.
Yes, Judge.
So anyway.
The allegations are that he's the owner of
the tow truck place?
Yeah. And then they found these cars that were stolen, that had issues with their...
Right, there's probable cause for the charges. Count 1, operating a chop shop, is $2,500. Count 2 and 3, grand theft of the vehicles, those are also $2,500 each count. And count 4. Oh, it's 4 counts, excuse me, it's 4 counts of possession of a vehicle with an altered ID, so...
Did you want to just say 2,500 and everything?
Yeah, I guess so. Is that okay, Mr. Cooper?
Yes, Judge.
All right. Thank you. How many? What's 4, 7? So counts 3 through 7, 4 through 7. Sorry, is $2,500 each count. All right, sir. You have a good attorney. Listen to what he tells you. You'll see your judge on Monday. Have a nice day.
Thank you, Judge. Thank you, State. Pleasure to see you.
Thank you so much.
Thank you.
So I do this actually on the misdemeanors too. I write PC felons. You know? Next, add attorneys for corrections. Page 2. Where's the calendar? Sometimes I never allow just because I use them for the boss, I guess. So let's go page 2. I'm sorry. Alendis Leon Ray, thank you, Leon Ray.
So I'm okay with just possession, maybe a program.
Okay,
For misdemeanor, she was given pretrial.
right, back, okay. Let's see, what is what you see, let me down and say this.
Spanish interpreter, please.
Good morning, ma'am. You were arrested for introduction of a controlled substance at a county facility.
Ok, señora, buenos días. Usted tiene una acusación por meter una sustancia regulada en las instalaciones.
I will appoint the public defender's office for you.
Voy a nombrar a la Defensoría Pública para que la represente.
So, state you have an objection, it's pretrial?
No.
¿Tiene alguna opción la Fiscalía para los servicios previos a juicio? No.
Pretrial services, alternate bond, $2,500. Have a nice day.
Ok, entonces está bajo la supervisión de Pretrial Services o la fianza alterna 2.500. Tenga buen día.
All right, next is Bijan Stone, page 7. Good morning, Mr. Stone. You were arrested for 2 cases, grand theft from October 26th of 2024 and fraudulent use of personal identification, fraudulent use of a credit card from July 31st. I will appoint the public defender's office for you. So let me review for probable cause.
Victims, his mom,
Sweetie, can't leave.
he changed
The
his
credit card.
account, credit card into his name and then made fraudulent withdrawals.
Charges, all right. So there's probable cause on F25-19861. Do you currently live with your mom?
Yes, I currently live with my mother, but me and my mother stay with my grandmother, so we all in the same household. But
Okay.
I stayed.
Can we pass it for a moment, Judge? We'll call his mom.
Right, so Judge, I did do a stay away order. I don't know if Your Honor wants to issue it or not.
If he's living with his, I don't have to issue the stay away order, but I don't know what mom wants to say. He's
Square
stealing
building
her
council is fine.
Yves Saint Laurent purse, her Gucci sunglasses. He pawned them. Are you getting drug counseling? Are you getting any type of drug counseling?
No.
You working?
No, I'm not working right now.
So what do you do all day?
I just go to the gym, chill
that's
my
good.
girl. I chill.
But you're
my
24. Don't you want to have ambition to do something positive in your life?
Nah, like I'm trying. It's like the area I'm in is so like I wish it's like I could have just changed my routes when I was growing up.
But you can change now. Why don't you enroll at Miami-Dade
But
and
I don't
try
have-
and learn a trade?
I
You know,
am.
what do you didn't tell me you're in school. You go to school?
No, but I did study my GED.
That's great. You know, you can go to a trade school, learn how to fix air conditioners, cars,
Correct.
machines.
I am a barber too as well. You know, I like side barber. You know, but I ain't
That's
never
great.
been
You can go
barber.
to barber school. I mean, but you need to get a job. There's no reason you can't go every day searching for a job. There's a lot of businesses looking for people that want to work, but
Yes.
you're going to be in a position. It's going to be hard if you don't have money. You want to be like take your girl out and do nice things.
Correct.
So you got to get a job.
Yes.
You got to work. Okay.
Yes, ma'am.
You want me to pass it then for C?
Yes, please.
Okay, I'll pass it to see if his mother wants to come in.
I just go to the gym and chill with my girl. Well, you know what? I kind of do the same. My girl and I went for a walk at 4 a.m. this morning, and that was us exercising, spending time together, and it was a little chilly outside, so we chilled too. I love people. Good morning. Happy Super Friday. Welcome to the Courtroom Files Live. We're going to ride with Judge Glazer for a little while. I'm a little bit behind on stacking up my courtrooms because of the breaking news this morning that kind of had our attention. So we're going to ride here as I continue to find out what else is out there. So let's go back to Judge.
The other case is grand theft of a vehicle. I will appoint the public defender's office for you.
So on page 5, it said that he admitted to stealing the trailer from the Garden Inn, so I believe there's probable cause.
Thank you. Is he out on felony bond?
I've got him out in case F25-14024A.
I'm trying to look at. I was there for the PC, but it tells it to me. Oh, that's a huge one. Just give me a second. Give me a second. I'm looking for the PC. She was with the Trellos. Right here. All right, there's probable cause for the charges. So he has a hold. I need that case number, please.
F25-14024A on.
F20. You can do a sticky. F25-14. Thank you. So he has a hold for F25-14024A. You're going to see the division judge on Monday. So on F25-194, I'm sorry, F25-19884, count 1, possession of cocaine. It will be $1,000. It's residue. And then the next case, grand theft of the vehicle, there's probable cause, $2,500 bond. Have a nice day, sir.
Spanish interpreter, please.
Next is Ramon Perez, page 12.
Ramón Pérez.
Hi, Mr. Perez. Good morning. You were arrested for possession of a stolen or fictitious driver's license.
Ok, buenos días, señor Pérez. Usted tiene una acusación por poseer una licencia de conducir falsa o robada.
Can you afford to hire a lawyer?
¿Puede usted pagar un abogado privado, señor?
Sir, can you afford to hire a lawyer? I see you're driving a Range Rover, a Land Rover. That's a fancy car.
Señor, usted puede costearse un abogado particular porque veo el tipo de auto que usted maneja y es costoso.
Es el carro de mi esposa, yo no tengo auto.
That's my wife's vehicle. That I don't have a car.
Do you own your home?
¿Usted es propietario de su propia casa?
No.
All
No.
right. I will appoint the public defender's office for you. There's probable cause for the charge. How long have you lived in Miami?
Ok, entonces voy a nombrar a Defensoría Pública para representarlo. Hay un motivo fundador para este cargo. ¿Cuánto tiempo lleva viviendo en Miami?
21 años.
21 years.
Right. First of all, he's charged as an unauthorized alien. I don't see anything here about that.
It's there, Judge. He stated he's got an order of deportation, but I don't see that he's got an ICE warrant.
Oh,
Yo veo que tiene una orden de deportación, pero no veo una detención por parte de ICE, de inmigración.
I didn't see that one. I don't usually see those here. So, sir, there's probable cause then for possession of a stolen or fictitious driver's license by an unauthorized alien.
Entonces sí, yo veo que usted tiene una acusación por poseer una licencia de conducir de manera ficticia o robada por otra persona.
So, sir, state what bond are you seeking? Do you want me to set it as the
Bond is fine.
The standard's an F2. You don't want 25 or 5?
That's fine too.
Okay, $2,500 bond. There's
Una
probable
fianza.
cause for the charge.
Hay un motivo fundado para este cargo y pongo la fianza de $2,500.
All right, have a nice day.
Tenga buen día.
Next, we have Eddie Philippe.
Bailey and Barbara showing their 5 months worth of support. Thank you so much. And Bailey, thank you for gifting a membership. Appreciate that. Michael comments, I think it's great they have extraterrestrials getting employment. Well, that's the MAMA program, Michael. Make America Martian again. Just saying. Bo gifts a membership. Thank you so much for that. Appreciate all of you. Oh, Donald. You got the gift membership from Bo. That worked. Congrats. You get to join us on the pre-show now. And you get early access to all of our videos, and you get a discount in our store and a bunch of other stuff. So congrats. Very cool.
Nothing yet.
Okay, he's going there next.
There's probable cause for the charge. So it's from 2024. Sir, you are ordered to stay away from the alleged victim, whose initials are ND. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Wrong page. Do you understand the stay away order?
Yes, Your Honor, but will I be able to say anything?
Don't talk about the facts. You're presumed not guilty. You have a good lawyer next to you. Talk to her, see what she says. Those are performance. So I just have a felony. See? The standard is a second-degree felony. It's a 7,500, but wait, it's 2024. State, what bond are you seeking on this? It's from 2024. Are you okay with a lower bond, lesser than the standard?
That's okay, Judge.
What are you suggesting? 3,500?
That's good.
$3,500 bond. Have a good day, sir.
So Barbara throws down a membership. Thank you. Lindsay throws down 5. Thank you for that. These are going to some people that we know too. Axiom is in and out quite a bit. He got it. I've seen Philip Ketchum before, so that's cool. Jimmy Powell looks somewhat familiar. So yeah, y'all need to go get a lottery ticket because this stuff is divvied out completely randomly, and these are people that we've seen before, so very cool.
So the passenger, underline passenger, and then you can underline his name. Good morning, Mr. Sanchez. You were arrested for grand theft of a vehicle, possession of cocaine, possession of drug paraphernalia, resisting an officer without violence. I will appoint the public defender's office for you. So he's a passenger, I agree.
Yes, ma'am.
I don't know, so
So it
maybe
asks if there's no
trespass?
public cause for count 1, Judge. You have to have knowledge the car is stolen.
That is true.
Trespass. So I'd ask for no probable cause for count 1.
State, you agree?
I don't, right now, I don't know if we have enough information to show that.
Count 1, no probable cause, release outright. And also, you see how it shows as an F1? In order for being F1 grand theft, it's the value of the flag, it's the knowledge of it. So count 1, release outright, no probable cause. Count 2, there's probable cause for possession of cocaine. Is he eligible for a program?
He came in on a bench warrant. He's listed as homeless. State's
Judge,
requesting
in case he has a place to stay, I would ask for pre-trial.
What happened to his bench warrant case?
Nothing yet, Your Honor. It's going later.
It's 3,500. That means he may have missed a trial. That's my concern. But he doesn't have a lot of priors. How long have you lived in Miami?
State.
Oh, I'm setting a bond. Count 1, no probable cause, release outright. Count 2, possession of what?
Would you do tap?
No, he doesn't go to court. He has priors out of state. What are his priors out of state?
It looks like he was convicted, it was a while ago, possession of a controlled substance.
How long has he lived here in Miami?
Sales.
Two
He's
years.
been here a year at least.
2
All
years.
right. I'll give him tap. Tap alternate bond, release outright, count 1. Count 2, $2,500. Count 3, $500. Count 4, $500. Sir, I'm going to give you a date to come back to court. You make sure you keep all future court dates. It's the arraignment date is October 14th at 9 a.m. Courtroom. No, it's no 1-8. That Brinkley and one other one don't have it right. So it's 2-1. Whenever you see 2-1-8, it's 2-1. It's like crazy here. Courtroom 2-1.
Go over state's objection.
500. What did I say? 500, right? Okay. Have a nice day.
So just to bring you up to speed, guys, we're going to hang with Glazer for a while because I'm not overly impressed with other things I'm seeing at the moment. There's a lot of landlord-tenant going on, which we might as well just all take a nap. We know how we feel about that. And Other courts haven't come online yet, so we're going to stick here. Grandma TCF. Mom throws down 5 memberships. Thank you for that. You rolled the dice with nobody I've ever seen, though, Mom, but thank you. Appreciate it. And Michael throws down a membership. You guys are great. So, look, Donald, who else? Doggone it. I was going to call you out, and I forgot your name. So let me go back in the chat. I'm so upset with myself. I forgot the name. Where is it? Liz Rose. You're new here. At least I've not seen you in the chat before. Those of you who are new, this is a great place to be. I don't say this just because it's the channel I run. I say it because I believe it. This is one of the best, if not the best spaces in LawTube. This is a good group of people. So take advantage of it. Enjoy it. This is a good place to be. Anyways, back to Judge.
You cannot be physically threatening or violent towards her in any manner whatsoever. So only friendly, nonviolent contact is permitted.
Okay.
You understand that, sir?
Yes, ma'am.
Also, do not engage in any criminal activity, do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. You understand the modified stay-away order?
Yes, ma'am.
Didn't I do pretrial yesterday?
I think you're only moved in house arrest. I don't remember, but
gave him a
the other
bond.
case.
Yeah, bond.
A bond, right?
Yeah, I got a bond.
35 the bond.
Oh, on this one you want pretrial? It's old.
Still pretty violent. The other case involved a gun.
Would you do
Pretrial alternate bond, $2,500. Have a good day. Yesterday. Okay. Oh, you said PC theft, right? You did that. Okay, thank you. So, all right, it's good. It makes it easier for me. Next on page 20, we have DeMarcus Butler.
What the facts are, and then I would decide if you've been proven guilty beyond a reasonable doubt.
And Ashley turns Super Friday into Super Duper Friday. Throws down 20 gifted memberships. Ashley,
Good morning, Mr. Butler.
Hush up, Judge Glazer. I'm talking. Ashley, you're the best. Seriously. Very much appreciated. All of you, very much appreciated. Like I said, this is the best place. This is the reason why I get up at like 3:30 in the morning. It's just to be able to spend time with you guys. It's the best. Donald throws down a $9.99 super chat. Thank you. Very much appreciated. Like I said, you guys are great. And I don't care what anybody says. This is the best place. Thank you so much.
Okay, so count one is, you see what you have it? So, sir, count one, there's probable cause for armed burglary. That's no bond. That's a first-degree felony. Count two, there's probable cause for grand theft of the firearm, $2,500. Count three, petty theft. And you took something else from there. That's the petty theft. There's a value, $200. So it's a first-degree misdemeanor petty theft, $500 bond, count three. Have a nice day. See you soon.
Super duper schmooper Friday? Bailey throws down 5. Thank you, Bailey. 39 gifted memberships so far. The record, by the way, is 72 in a day. I'm not saying that we have to hit the record. I'm not throwing that out there to say go beat the record. It's just more to let you know where we're at. But like I said, you guys are the best. I like the fact that you guys gift the memberships because it just brings more people into the family and exposes more people, and I think that's great. So thank you so much.
Your bond is $2,500.
Victim's name is Anthony Caruso.
So your bond's $2,500. Have a nice day. Let's put today's date. So it was yesterday. I was put today's date. So yeah, so we always know. Let's say they were here. Okay, there is a question. And then we have James Walden, page 23. Good morning, Mr. Walden. You were arrested for accessory after the fact. It's charged as a second-degree felony. I will appoint the public defender's office for you.
Wait, so he comes to the camera during a fight at the jail.
Okay. My $2,500 bond?
That's good.
It's probable cause for the charge. So there's probable cause for the charge, $2,500 bond. Have a nice day.
Barbara throws down 5 more memberships. Thank you so much for that. Donald wants to know how my last name is pronounced. It's pronounced Soul. Kind of like heart and soul, only a little more wool at the end, perhaps. Soul. The proper French is Soule, but soul. That's what we do.
What'd you say? Which one you want?
48 and 49, page 19.
So these are the pages usually we're
And Judge, we can also go back on Mr. Stone.
What, I'm sorry, one more time, the names.
It's Jonathan Dixon.
Got
and
it? What?
Well Pittman.
Got him. So you see here, the one pull everything. Let me see this.
Oh, on 48, he is a private attorney, Thomas Rizave.
Is he here?
He's a direct file.
Oh, okay.
This is Mr. Pittman, Judge. We do have Mr. Pittman. Hi, Mr.
All right. Good morning, Mr. Pittman. Sir, you were arrested pursuant, what were you arrested for? No, it says file, direct file. So Mr.
No, this
Pittman,
is
oh, is
Mr.
Mr.
Pittman's not a
Dixon or
direct file.
Pittman?
This is Pittman, Mr. Pittman.
Pardon me.
Yes.
Good morning, Mr. Pittman.
Good morning.
Sir, you were arrested for 2 cases. The first one is armed robbery with a firearm or deadly weapon. That's from August 2nd. And the other case is armed robbery with a firearm or deadly weapon and 5 counts of fraudulent use of personal identification. I will appoint the public defender's office for you. Give me a moment to review for probable cause.
While she's being quiet, I just want to take a moment and say thanks again to everybody. This has been quite the first 30 minutes of our show today, and I really appreciate it. Those of you who have been around know how bothered I've been by the events of this week, and the community here. I kind of really needed this today. As I was just explaining to Michael in the chat, this isn't a money thing. It's you guys rally around each other and you rally around me, and I needed that. So thank you. Thank you for a super duper schmooper Friday so far. Appreciate it.
Okay, there's probable cause for the charges on both cases. So you are ordered to stay away from the alleged victims, Austin Mahone, and the alleged victims for the other case. His initials are GML, RLL, and WAG. Those are the victims from the food court, the food truck robbery. No contact with those alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victims through social media or other electronic means. And you must stay at least 500 feet away from the victims, their home and school, and place of employment at all times. Do you understand? And also stay away from the Dolphin Mall. Do you understand the stay away order, sir?
Yes, ma'am.
All right, thank you. So as to both cases, the state filed a motion for pretrial detention pending final hearing pursuant to Florida statute 907.041. So let me. So on F25-19904 for the charge of armed robbery, it's no bond. And then the other case, F25-19898, count one, armed robbery with a deadly weapon, is no bond. I'm granting the state's motion for pretrial detention pending final hearing. And then the other count is charged with 9 counts of fraudulent use of identification. 5 counts, excuse me, not 9, 5 counts. I'll set a bond on those. What do you want me to set? $2,500 each count?
That's fine.
$2,500 bond counts 2 through 6. So, sir, you'll see a judge on Monday, and that judge will set a final hearing on the state's motion for pretrial detention. Have a good day. Each count. So I have to write it out 5, 6 times. To 6. And stay away from the victim. Did I do it right? I did. Oh, okay. The initial. Always put your initials. Okay. Look at some ladies. Who am I calling up again? You wanted me to recall Jonathan, or did you want me to call Jonathan Dixon?
Yes.
Ms. Court, you said Dixon has a private attorney?
Yes, Thomas Rizave.
But he's not here.
I think he may be logged on. Hold on.
Is he here? Mr. Rizave, are you here? If you are, please raise your hand on Zoom.
I thought I saw him.
Good morning, Mr. Dixon. Sir, you were direct filed from juvenile court. I see you are 16 years old, so good morning. 16, he should be 17, no? No, 16. He's going to be 17 in December. So you were direct filed from juvenile court. The information is charging you with carrying a concealed firearm and possession of a firearm by a minor. So even though they didn't charge you. Just this is the information. So I'm told you have I guess a SAPD attorney or regional counsel. I'm not sure. Have you, or did you hire a private lawyer?
Yes.
You hired a private lawyer?
Yes.
Mr. Rizave is your lawyer?
That's what I've been told by my office, Judge.
So right.
Yes.
Thomas
Yes.
Rizave. He's not here now. You have a hearing on Tuesday before the division judge, but he's entitled to a bond on this case.
You're bondable, yep.
But I don't feel comfortable proceeding without his lawyer. Let me see if we can reach him. You want to call him, Miss Eth, and see if you can reach him, or send him an email?
I don't know, like, I don't have his information, but I could look it up.
I mean, I'll call him if you can give me a number. It's an information. Okay. It's been filed by the state. We'll do that after. No, you do. Sometimes you still want to check it, but yeah, there was a. These are the TAP referrals. You know,
There we go,
the
Judge.
homeless people will so people.
Let's see, here's a number.
Any luck?
I didn't call it, but here's the number.
Wait a minute. Renee, you want to call him, see if you want to log on? 786-295-9946. So let's try and get your lawyer here. 786. Here, think you can call him, see if he can log on to Zoom? I gotta wait. I can't drop everything because a lawyer pops in. I'm sorry. All right, we're good to go. We'll pass your case, sir, for your lawyer. Have a seat. We'll be with you shortly. Do you want me to recall Bijan Stone?
Yes, Judge, I'm told his mom is logged in. If she can raise her hand on Zoom, please, I can promote you.
Look for Zoom for his mom. Her name shows. I don't know, she may be under the
Miss Stone? Miss Stone, if you can raise your hand, please, on Zoom.
Sit down. Start. Unless they're gonna do it. So she'll do it. She's gonna promote it. Are you doing it, Miss Corey?
Yes.
Do it. Sure. Might better.
She's rejoining now.
Having my office running on. My kids used to play with little Russian dolls. They used to talk about that.
Miss Stone, if you can unmute and turn on your video, please. You see a microphone button and a little like video camera button you can push.
She there? Come on, Miss Stone, you there? But I promoted her. Who did I promote?
Miss Stone?
Miss Stone, we need you to unmute and put on your video, please, if that was you. That wasn't her. She raised her hand. Was it Samsung or no?
Yes.
Hello?
Hi, good morning, ma'am. Please raise your right hand and be sworn in. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I swear.
Thank you. Please tell me your name.
Cherie Stone.
Ma'am, are you afraid of your son, Bijan?
Yes, I really don't want Bijan around me.
Thank you for letting us know. Okay. So, sir, Stacey, did you have any questions?
No questions.
Ms. Corey?
No questions, Judge.
Actually, I do have a question. Ma'am, what's going on with him? Is it drugs?
To be honest with you, I don't know what's really going on with Bijan, for Bijan to be doing needy stuff. It's not the first, it's not the second, it's not the third. It's an ongoing situation with Bijan. I reached to a point right now, I'm very tired. Bijan don't want to work. You cannot stay here. My mom, I'm fear for my life. Last year, I almost lose my life because of Bijan. I'm tired. I have a mom bed in a wheelchair that I have to take care of. Every minute, shooting. My house is shoot up. I can't have Bijan around me right now. I'm very sorry.
Okay, so, sir, I am entering a stay-away order from your mother, Cherie Stone. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. You may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal belongings. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order?
Yes, ma'am.
Okay, State, you want a bond or what do you want? House arrest?
Even on a bench warrant, house arrest if he's got somewhere else to live would be fine, or a bond.
Judge, he does have another place to stay. Would Your Honor consider pretrial?
No, maybe house arrest. Mom said she's in fear for her life. 1 second.
There's at 364 and 22. I can see if that was with mom.
Sometimes I have to write it in here. This doesn't qualify for like the domestic. It's not technically domestic violence. All right, so I'm setting a bond on F25 19862, the charges of grand theft to house arrest with a GPS monitor. Alternate bond will be $2,500. Level 3 house arrest, that's GPS roaming with a curfew at night from 11 p.m. to 6 a.m. with the stay away order. The other case, pretrial, I'm sorry, it's house arrest, GPS monitor, alternate bond, $2,500 count 1, $2,500 count 2. Level 3 house arrest with a curfew from 11 p.m. to 6 a.m. Thank you. Have a good day. Thank you for coming in, ma'am.
All right, we've been riding in Miami-Dade for about 40 minutes now. I'm mostly unimpressed with other things I'm seeing, though, but I'm going to put us in the Wayback Machine. This was from earlier this morning, not that long ago, an hour or so ago. This is Judge Anzalone in Lenawee County, Michigan. She had a sentencing and pickup docket, so let's spend a little time with her.
Is familiar with the fact that people, no matter how well they're doing, occasionally have relapses. And I think that's what Ms. Spiegel found herself doing, Your Honor. And she apologizes, and she knows that recovery court is the proper place to address that. And she welcomes the opportunity to do that. And I think she welcomes the opportunity to sit down with Ms. Tetsky and decide what kind of future treatment is appropriate. And the sooner she gets back into recovery court, the better, Your Honor.
So, thank you. All right, Ms. Spiegel, anything you want to say on your own behalf?
I just want to say thanks for giving me another chance.
Okay. Ms. Teskey, anything you want to add?
No, Your Honor.
All right. So it is a sentence of the court that on docket number 22-20816FH, we will revoke her probation without improvement. On docket number 24-21737FH and 24-21738FH, I'm going to continue you on probation and in the recovery court program. I am going to order you to serve 6 months in jail with early release to residential treatment. So Ms. Teskey will work on setting that up, or someone else on the team will. And then you are not to have any contact with Joseph Strong, okay? Verbalize that. Okay. Yes. And okay, good. Ms. Spiegel, you know, you've done amazingly well and things do happen, but I believe that you can overcome this, and I hope to see you soon in recovery court, okay? Mm-hmm. All right, now you do have the right to appeal this sentence, and they're going to give you 3 copies of your notice of right to appellate review. They'll have your initial and date, 1 copy on each file for our records. The other copies are for you. And if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay.
Thank you. See you
Thank
soon.
you. Yep, hopefully see you soon.
Yeah, you will. That's the shortest wait you've ever had.
I know, I was like, geez,
Yep.
Her eyes must still be sleeping. Thank you.
You're welcome. All right, I have somebody at the jail. What is your name, please?
Melanie Lehman.
All right. Get in there. Find your file. All right, in the matter of Kathy Ann Wilzer versus Melanie Lehman, file number 25-52956PH. This is a Judge Olsaver file that I'm handling. He is not in today. So we have a personal protection order that was filed on September 5 of 2025. And I show that it was served on September 7th of 2025. And Ms. Lehman did sign an acknowledged service, and it was by a deputy rights scam or something like that. So Ms. Lehman, we are here today on alleged violation of the PPO. Let me see what the show says. Hold on one second. So, Ms. Underwood, as I just wanted to give you a heads up, but when I reviewed the information on the jail sheet, it says obstructing court order. I'm assuming that's just the PPO, and I don't show that there's anything else listed there. So, Ms. Lehman, it is alleged that you violated the personal protection order, and that on or about September 11 at 1300 hours, you flipped off the protected party, flipped off the neighbor protected party door. You then went up to the door and put your head up against the door. Throughout the day, you had been seen walking in front of protected party's front window. Protected party felt harassed and threatened. So it looks like you guys maybe live in a duplex next to each other. Hold on, Ms. Lehman. So those are the allegations against you. Violation of a PPO can carry up to 93 days in jail and up to a $2,000 fine. So Ms. Lehman, you do have a right to have an attorney represent you here today. If you can't afford to hire one, we will appoint you one at public expense. Ms. Underwood handles these matters for my court. Would you like a court-appointed attorney?
Yes, please.
Okay, so I am going to open up a breakout room.
Am I able to speak at all?
You will, now that you've asked for an attorney. You'll get to talk to her, and then you guys will come back in and we'll see what we're gonna do.
Okay, thank you.
You're welcome. All right, Ms. Underwood, join the breakout room.
All right, let's switch things up again, because it's number one, it's Friday. Number two, when there's not a whole lot going on, we can try new things. So in Allegan County, Judge Belergian retired a couple of weeks ago, and he was replaced by Judge Christopher Burnett. I have not watched this judge yet, but he does have a docket going this morning, so let's take a look and see what he's all about.
Identify yourself for the record.
Yes, Brian Scott Nelson.
Thank you, Mr. Nelson. So I have in front of me a pretrial form that is indicating that Mr. Nelson will be entering a guilty plea to an amended charge of operating while visibly impaired. In addition, the prosecutor is indicating that we may sentence immediately, and they're waiving their presence of sentencing. Other than that, counsel, did I state the agreement accurately as far as you're aware?
You have, Your Honor.
And Mr. Nelson, did I state the agreement accurately based on what you know?
You have, Your Honor, yes.
And Mr. Towson, the impairment, is that due to controlled substances?
Yes, Your Honor. It was a prescription medication that my client is no longer taking.
Mr. Nelson, is this the agreement that you wish to enter into?
Yes, it is.
Beyond it's been stated on the record, have there been any promises or threats of inducement to force you into this plea?
There have not, Your Honor.
Is it your own choice to enter this plea?
Yes, it is.
When you were arraigned, do you recall reviewing your advice of rights?
Yes.
And you understand that by entering a plea, you will be waiving those rights, including your right to be tried by a jury.
Yes, I do.
So, as to the offense of operating while visibly impaired by drugs, how do you wish to plead? Guilty or not guilty?
Guilty.
I'm going to have you raise your right hand, please. You swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Very good, thank you. You can put your arm down.
Okay.
Mr. Nelson, on June 24, 2025, were you operating a Subaru on northbound US 131 at or near the 57-mile marker around 7:15 a.m. in the township of Martin, County of Allegan, State of Michigan?
Yes, Your Honor.
And prior to operating that vehicle, had you taken some kind of controlled substance?
I took the prescription for sleeping at approximately 10 p.m. the night before.
And that was a Ambien?
Correct.
And did the lab report come back, Mr. Towson?
Lab report did not come back, Your Honor.
Okay. Are you comfortable proceeding without the lab report?
We are.
Mr. Nelson, do you believe that by taking that controlled substance, Ambien, it impaired your ability to operate that motor vehicle?
I do, Your Honor.
Was there some bad driving that would have been apparent to an outsider?
Yes.
Okay. Mr. Townsend, are you satisfied with the plea?
I am, Your Honor.
The court is as well. The court will find that the plea is knowingly, voluntarily, and accurately made. The court will accept the plea. Mr. Towson, for sentencing, what would you like the court to be aware of?
Your Honor, back in 2000, my client had a minor in possession of alcohol. Other than that, he has nothing else on his record. He has a good driving record as well. He's 45. He recently lost his job. He is searching for new employment. After this incident, he was very shocked and afraid about what happened. He contacted his physician and is no longer prescribed and is no longer taking that medication. He's made some very good changes in his life since then. He knows that this is certainly a situation he doesn't want to be back in front of you or any other, and it certainly is within its power to make sure that it doesn't happen again. I believe the evaluation is complete, it's accurate, it does call for some individual outpatient counseling. I would ask that the court place him on a short period of probation to, in fact, follow through and complete the counseling. And he has reached out to Lutz at New Way Counseling to follow through with the recommendation. Thank you.
Thank you, Mr. Towson. Mr. Nelson, is there anything that you wish to add to that?
There is not, Your Honor.
Okay. It does appear that you had a crash in 2021 with controlled substances and alcohol was not involved. What happened there? Do you recall?
I honestly don't. In 2021, there was an accident.
5/10/2021, failure to yield in Jackson County. Is that something that you recall?
I have. Oh my goodness. Okay, sorry. I had to think about that. So there was merging traffic onto in a construction zone, and I was in a place that a semi couldn't see me and it hit me, and I didn't think there was that much damage, which it doesn't matter whether it was or wasn't. And I got a phone call, and police officer caught up with me, and we chatted, and he gave me the necessary paperwork, and we went on.
Okay, and you were successful in doing a driver improvement course back then?
There was not anything I needed. He actually, I don't remember getting a ticket for that. I remember him checking the things he need to, and that's it.
Maybe you were eligible, but you never needed to do it. That's possible. Okay. Well, Mr. Nelson, I appreciate you coming here, taking accountability, and actually being proactive in getting involved with New Way counseling. I think that that's a very important step in you acknowledging that there might have been a small issue that you do not want to turn into a bigger issue, and you're taking the proactive steps to make sure that things like this don't happen again. It sounds as though, based on the New Way counseling report, that controlled substance can cause almost daytime sleeping while you're sleepwalking type behavior, and that sounds as though that's what was going on here. That sounds like a very scary situation to be in, not really knowing where you're at or what you're doing. So by getting off that medication, I think that is a smart move on your behalf, and doing other things to try to help yourself sleep in a healthier manner, so that this doesn't happen. So I certainly appreciate that. What I'm going to do is I'm going to follow your attorney's recommendation. I'm going to order 6 months of probation. And while you're on probation, you may not consume any alcohol, marijuana, illegal drugs, or other intoxicating substances, and you could be tested randomly. It doesn't seem like that's going to be a problem for you based on the self-report to the counselor. While you are on counseling, I do want that, I'm sorry, while you're on probation, I do want you to continue in counseling to address controlled substance issues, just so you have some awareness of that.
Absolutely.
Like Wednesday afternoon, everyone's in court, everyone's in court.
Other than that, I will be ordering a victim impact panel as well. The victim impact panel, as I'm sure Mr. Towson will tell you, is a brief seminar where you get some education about the risks of drinking and driving, or drugging and driving, and how that can impact families. I've been told that that can be one of the more eye-opening aspects of this whole process. So you can do those online. There are various ways to get that accomplished, but it shouldn't be a major issue for you either. Just make sure that you take care of that, please.
Absolutely.
Yeah, you're very welcome. While you're on probation, you do have fines and costs that need to be paid to the court. You'll have a fine of $400, state costs of $50, other statutory costs of $400, crime victim right fee of $75, and an oversight fee through probation of $180. That is a total, I believe it's $805. Better check my math. Oh. Sorry, so $905, and that will be paid over the course of the 6 months. And I will mark down that you are out potentially eligible for early discharge pursuant to MCL 771.2 It would mean that if you are cooperative, have no violations, and have all your fines and costs paid off, you could be off probation as early as 3 months, sir.
Thank you, Your Honor.
Okay, you're welcome. I do want you to take this seriously, and I think that you are. So with that, I wish you the best of luck. How long will you need to pay that $900?
I'm fortunate enough to take care of that right now if necessary. I mean, today.
Okay. I'll give you 30 days.
Okay.
Thank you, Judge.
Thank you.
Thank you very much. Have a nice afternoon and a good weekend.
Okay, so my first impressions of Judge Burnett is raw. You can tell he's a rookie, but we'll keep an eye on him and see how he develops. But let me know what you think in the chat. That's my first impression. Let's go back to Judge Anzalone.
With her knee, I would suggest that Ms. Lehman has been cautioned to avoid even the appearance of contact, Your Honor. They do live in close proximity, but it was supposed to be possible for them to do that. She now understands that she needs to not even wink in their direction. I would ask that a not guilty plea be entered and a date be scheduled for Judge Olsaver, and Ms. Lehman be released on PR, Your Honor, with the caution that nothing else.
Is she gonna plead then?
No, I'm just going to plead not guilty, Your Honor.
Okay. All right, I will, Miss Adams or Miss McGrain, when can I set this over next week? In front of Judge Olsaver. I guess she's gonna be in the hospital or something. Is it outpatient, Miss Lehman?
It's outpatient, but my doctor doesn't want me leaving the house for at least 3 to 4 weeks. So if we could do Zoom, I mean, that's why I petitioned on the paperwork for that.
Okay, that's enough, Miss Lehman. Hold on, I don't want you to say anything you shouldn't. So, one, Miss Lehman, you're an intelligent woman. You absolutely knew you shouldn't have done this, so I don't think anybody need to caution you. This is not a de minimis violation of the PPO when you go out of your way to make sure that they see that if in fact you did that. So I am going to set this out.
Judge Becky's on the phone with Ms. Clark.
So next week won't work. It would have to be probably 30 days out.
Judge, is this going to be just like a pretrial or a hearing?
Yeah, in front of Judge Olsaver.
Wednesday, October 8th at 8:15.
All right, so Ms. Lehman, I'm going to enter a not guilty plea. I'm going to set it over for a pretrial on October 8th at 8:15 in the morning. That should give you time to recuperate. Ms. Lehman, understand if there is one more allegation of a violation, you will sit in jail. Do you understand? Judge Olsaver, does not like people messing with his PPOs. So I will release you on a PR bond. I don't want you even, is it the same duplex or next door?
I can't even sit outside next to her. We have chairs both outside.
I know what it is. Yeah. So I don't want you looking at her. I don't want you walking on her side of the property. I don't want you to do anything. So we'll see you back on October 8th.
As long as I stay on my side.
Yeah.
I mean, that's what I mean.
That also means you don't flip her off from your side or yell at her or say anything. So October 8th at 8:15, I'll release you on a PR bond. If you violate again, though, there won't be a PR bond. So we'll see you back in front of Judge Olsaver on that day. Thank you.
Thank you.
So Ms. Underwood, Mr. Barnett did report to probation on Tuesday, but he's not here. Do you want to try to reach out to him?
I talked to him. Okay.
Uh-oh. Let's go back to Miami-Dade. They've hot swapped Glazer. I wonder what happened.
Read paragraph number 7.
You are also not to engage in any criminal activity or possess any illicit or illegal drugs. And in the event, or because the victim is a child, or the alleged victim is a child, you are, I'm going to go ahead and read it for the record. In the event that the victim in the above captioned case is a child and the victim and the defendant are in the subject of a separate case arising in the dependency division from the same set of facts and event as the instant case, then any and all orders of the dependency court related to contact, visitation, and custody shall supersede this order. So, ma'am, if there is a dependency case that has been open or will be open, the terms of that order or those orders will be subject, or you will be subject to them, and they will be subject to this case. Do you understand, ma'am?
Yes.
I am also entering that you are, or modification that you are allowed to have, like I said, supervised contact with the victim, and you are prohibited from being physically threatening or violent to the victim in any manner whatsoever. And state you were asking for pretrial services?
That's fine. Not objecting to it.
All right. I'm going to set an alternate bond of $1,500. All right, ma'am, best of luck to you. And I hope you do get better. Thank you so much. Next case, Morgan Nicole Rell.
I'm sorry, Your Honor.
So 2 things. Number 1, correct me if I'm just completely wrong, but does she or does she not look like Judge AOC? There's some AOC vibes going on there for me. Number 2, completely random, but I just opened this up. Chobani vanilla mango passion fruit yogurt. I've never had this flavor before. It might just be the best yogurt ever created by a man or a woman or whoever created it. It's really good. So check it out. Vanilla mango passion fruit Chobani. Back to Judge.
Ms. Rell, good morning. You are here because you're being charged with a first-degree grand theft of a vehicle, first-degree felony. I have reviewed the A form.
So, Judge, there's PC for a 3rd-degree felony. She may qualify for the TAP program.
All right, ma'am, are you homeless currently?
She has a place to stay, but there's no one there to confirm. If we could do the TAP program, Judge.
Okay. All right. All right. So we are going to go ahead and set her on the October 14th calendar, and it is courtroom 2-3, October 14th, 2025. You are to return to court, and we will put the TAP program alternate bond $1,500.
Does she have an address?
Ma'am, do you have an address? She stated that she didn't have anyone to verify, correct? Okay. Okay. So yes, just tap with the alternate bond, 1,500, I think.
And we are giving her the future court date?
Yes, of 10/14/2025.
Okay, thank you.
All right, thank you, ma'am. Good luck. Next up, we have Desiree Gator.
This case was reset to see if the defendant could go to the hospital. Miss Corey sent Judge Glazer an order yesterday. So if Your Honor, could set an alternate bond. The state's request is custody release to Southern Winds, alternate bond, 5,000 count 1, 500 count 2.
Right, so I will go ahead and order custody release. And can you clarify the name of the hospital?
Southern Winds.
Southern Winds Hospital.
All right, with alternate bond on count 1 of 5,000 and alternate bond on count 2 of 500. I believe that probable cause had already been found by Judge Glazer.
Ms. Corey, did Judge Glazer sign the order?
I don't see an order here. She did yesterday. They're telling me here in court.
You signed it yesterday?
She signed it yesterday?
Before she left?
Before she left, yes.
Before she left, I sent it to her after court yesterday.
I can verify. I can have them verify, and I will come back and let you know. But the court personnel are telling me that she did sign it.
Okay, thank you.
All right, thank you so much. Next up, I have Maria Van Kenehem. Is that correct? Did I state your name correctly? Miss Van Kenehem, are you
She's coming up, Your Honor.
Oh, okay, I'm sorry. Here we go. Maria Van Kenehem. All right. Miss Van Kenehem, you are here because you have been charged with 2 charges. One is the third-degree felony for grand theft and a third-degree felony for organized scheme to defraud. I am going to take a minute and review your A form.
These are added charges.
I do find probable cause as to count 1 and 2. State.
Not a charge, just requesting the standard bond, which is 2,500 per count, as well as the stay order.
All right, ma'am. Are you able to afford an attorney, or will you be hiring an attorney? All right, so I will appoint the public defender's office. I'm finding probable cause as to count 1 and count 2, and I am setting the bond at $2,500 each count. All right. All right, ma'am. Have a good afternoon. I'm sorry, excuse me. I am also entering a stay away order. You are to stay at least 500 feet away from the alleged victim, Leslie Angulo. You are not to contact her by telephone, by pager, through text, or through third persons. And you are to stay away from her home, her place of employment, and/or school at all times. Any electronic contact, such as emailing, texting, Facebook messages, or tweeting, is prohibited. Do you understand, ma'am?
Yes, Your Honor.
Thank you.
Thank you. Have a nice day.
I'm sure she needs
Thank you. All right, next case I have is Jaquina Everett.
Bond it out.
Okay. All right. Up next, I have Joyce Campos.
Ms. Campos is present.
All right, Ms. Campos, good morning. You are here because you've been charged with a third-degree felony of controlled substance, possession of cocaine, and a second-degree misdemeanor of petty theft. I'm reviewing the A form.
Miss Corey, is she really homeless? Do you want to waive the issue for pretrial?
We'd ask for pretrial. Ms. Campos can live with her father. He can confirm the address. She's lived here all of her life.
No objection.
Right, so
Instead of 2,500, sometimes should be 2,000.
so because the defendant is listed as homeless, I do want to go ahead and put the address where she says she has residence.
30905 Southwest 194th Avenue, Homestead, Florida 33030.
All right, and the state and defense are stipulating to pretrial services. For alternate bond state,
2,500 and 500, please.
all right. Okay, 2,500 as alternate bond for count 1 and 500 alternate bond count 2 with pretrial services stipulated to. All right, so ma'am, I am entering a stay away order for you to stay away at least 500 feet away from Walmart located at 33501 South Dixie Highway, Florida City. Do you understand, ma'am, that you're to stay away from that store? At least 500 feet away from that store.
Yes, ma'am.
All right. Thank you so much and have a great day. Next up, I have the case of Tracy Burns. Miss Burns, good morning. You are here because you've been charged with a second-degree felony of aggravated battery with a deadly weapon. I am going to review your A form.
So, Judge, this happened on July 29th. The allegations are a stabbing, and the victim needed approximately 27 stitches. I think this should more appropriately be a first-degree felony rather than the second.
Review. I do find probable cause as to a first degree.
Would Your Honor reset the case for the afternoon, and the state will file a motion for pretrial detention?
Yes, we can go ahead and reset. Yes, reset for the afternoon.
While she's here, though, Judge, can you issue the stay away order?
All right. So I will issue the stay away order right now, even though it's being reset for bond in the afternoon. You are to stay away from the victim, Miss Burns, from the alleged victim MT are her initials. You are to stay at least 500 feet away from the alleged victim, her home, place of employment, and or school. You are not to contact that victim through phone, text, email, Facebook, or other social media. Do you understand, ma'am?
Yes, do I have a bond?
At this moment, no. We'll be seeing you in the afternoon to determine what the bond is, okay? Thank you so much for your patience.
All right, let's change it up a little bit. Let's go to Texas, Jefferson County, and say good morning to Judge Rubber Gloves.
Right? No.
Okay. Well, that's a trial setting also, so.
Yeah. Yeah, so you're gonna reset, let me see, these cases, 260, one was 267, the other one was 268, 268 days. Oh. Okay, from filing. Okay, now, Mr. Shelnut has a, excuse me. He has a DWI second. And I need to give you some bond conditions. We're gonna put his case on November the 17th too as well? Okay. Mr. Shelnut, your cases will be reset for trial November the 17th, 2025.
Yes.
Okay. Reset. Now, Mr. Shelnut, I need to give you some bond conditions. Hold on a minute. I'm sure this is DWI second.
I'm trying to get it to them, I don't know why.
And were you required to get an interlock device?
Yes.
Okay, okay. Let me look at the file. It should be in the file.
Hey, that's good, boy.
It's Mosby. Want y'all, if y'all gonna close that door, we in session. It's Shelby. Taking a while for this computer to come. No. Okay. Here we go. Which one? Is it under 91? In 90, 57. Okay, I see it. Okay, I see it. It's in there.
Yeah.
Okay. Now, Mr. Shelnut, I have before me a document that is titled Standard Bond Conditions in County Court at Law Number 2. You'll get a copy of these bond conditions, okay? I'm going to go over these bond conditions. It says, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 does not apply. However, condition number 4 applies because your case is a DWI second, which is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the device if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the date. And I just looked in the file, you already have it.
Yes.
Okay, so we verified that. Let's see, condition number 5 states defendant shall obtain, maintain, pay for, and have no violations with the initial interlock mobile breath device. Any violation will be grounds for revocation. Do you understand that?
Yes.
Okay. Now, condition number 6, defendant must attend AA, NA meetings 3 times a week and provide proof to the court. Do you understand that condition?
Yes.
Okay, now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Now, I have a sign-in sheet.
If I may, I would lodge the same objection to condition 6 as I previously lodged, in that it violates defendant's rights under the First Amendment to require him to acknowledge a higher power, as NA or AA both require as part of the 12-step program as established in the big book, that would impose upon him an affirmative duty by the state to acknowledge a higher power to participate in either one of those 2 programs.
Okay, so now I can allow him to participate in the ATAR program, which is Addiction Treatment and Recovery Program, that does not require him to acknowledge a higher power. And with that program, what we'll do is, in these bond conditions, allow you to attend and complete the Addiction Treatment and Recovery Program through Spindletop. And we'll give you contact information, and then they'll be able to set something up with you. I think you probably could either do it in person or do it online.
Okay.
Okay?
I'm just trying to figure it out with my work schedule.
Okay, they should be able to work something out. It should not interfere with your work schedule. Okay? All right? So now, do you understand that condition? We're gonna, the condition is for you to attend and complete the ATAR program. Okay, through Spindletop. Now, you're gonna get a copy of these bond conditions. Once you get a copy of these bond conditions and you're reset, you're free to go. You have a blessed day. Have a seat in that first chair on the wall and wait for your name to be called.
Thank you, sir.
Okay, you're welcome. And Mr. Kimler, I think this is your last case?
Yes, Your Honor. Have a good weekend.
Okay, same to you. You have.
All right, let's go to Adams County, Colorado. This is the Zebra Court. Let's see what's going on there. Bond hearings, I believe.
Let me take a look. I do see that minute order from September 5th indicating that bond was set at $20,000 cash or surety with SRP and monitored sobriety. So we'll make sure that the bond reflects that it is $20,000 cash or surety with SRP and monitored sobriety. But Ms. Martinez, you are not eligible for a bond argument today. I will appoint the public defenders to represent you while you are in custody. Your next court date will be in Division R2 on September 18th to set a preliminary hearing at 1:30. That's Division R2, September 18th, 1:30.
I have court that day already.
Court's going to call People versus Marty V. Hill.
How you doing, Your Honor?
Good morning, Mr. Behill. This is 25 CR 1849. In this matter, you were arrested for failure to appear. Your bond is set at $7,000 cash or surety. You are not with SRP and monitored sobriety. You are not eligible for a bond argument this morning, but I will appoint the public defenders to represent you while you are in custody. Mr. Behill, your next court date will be September 18th in Division R2 at 1:30 to set a preliminary hearing. Good luck, sir.
Thank you.
Court's going to call People versus Kimberly Winkle. Good morning, Miss Winkle. You've got 5 matters we need to talk about. The first is ET 207759B. It looks like a case out of Arapahoe County where you were arrested for failure to appear. Your bond is set at $75 cash or $500 surety. In 24M800573, that's a case out of Broomfield where you were arrested for failure to appear. Your bond is set at $500 cash or surety. You've got Jefferson County case 25M2858 where you were arrested for failure to appear, where your bond is set at $50 cash. Then you've got 2 Adams County cases, 25M1821, where you were arrested for failure to appear. Your bond is currently set at $25 cash. And 25M2419, where you were arrested for failure to appear. Your bond is also set at $25 cash in that case. In your Adams County cases, ma'am, you are not eligible for a bond argument today, but I will appoint the public defenders to represent you while you are in custody. Ms. Winkle, your next court date in Adams County is going to be September 22nd in the First Appearance Center for an arraignment at 1:30. That's September 22nd, First Appearance Center, 1:30. I will appoint the public defenders to represent you on those Adams County cases. For the out-of-county cases, ma'am, I don't have the ability to adjust or modify those bonds, but we'll let those other entities know where you are, and hopefully they will come see you shortly. Good luck. All right, that gets me through all of my cases that I don't think are eligible for bond arguments. I'm going to start with the stipulated personal recognizance bonds. Court's going to call People versus Ashley Punahole. Punahole?
Yeah.
Ma'am, how do you say your last name?
Punahale?
Punahale. Ms. Punahale, this is 25M689. In this matter, you were arrested on a warrant. So I will appoint the public defenders to represent you while you are in custody. We need to address a mandatory protection order. We need to address your bond, and we need to get you a new court date. In this matter, I am going to issue a mandatory protection order. The protected party is Dylan Trulinger with the date of birth that's listed on the pretrial services report. I'm going to check boxes 1, 2, 3, 4, 5, 6, 7. Counsel, do you know if this defendant needs a civil assist?
I believe we do.
I will authorize 1 civil assist for you to get any undisputed personal property out of the home of Mr. Trollinger. Ma'am, what this means is that you may not have any contact whatsoever, directly or indirectly, with Mr. Trollinger. You must vacate his home and stay away from any place that he is likely to be found. You shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or the victims of the acts you were charged with committing. Additionally, you may not possess or purchase or control any firearms or any other weapons or any ammunitions, and if you have any of those things, you must relinquish them to the appropriate authority within 24 hours of your release, and then file proof of relinquishment within 7 days after that. Additionally, you may not possess or consume any alcoholic beverages or controlled substances without a valid prescription while this protection order is in effect. Ma'am, I am authorizing 1 civil assist for you to get any undisputed personal property out of the home of Mr. Trollinger. You'll have to schedule that with the Sheriff's Department when you get out of custody. You may not go over to Mr. Trollinger's home without a sheriff's officer present. I have to advise you that violation of this protection order could result in additional felony charges of witness tampering or witness intimidation or violation of a protection order, so don't violate that protection order. The district attorney has stipulated to a personal recognizance bond for you, so I'm going to set your bond in the amount of $1,000 personal recognizance, which means that you should be getting released as to this case today. Your next court date will be September 18th in Division R for an arraignment at 1:30. That is September 18th, Division R, 1:30. Don't forget to come back to court.
All right, thank you.
Thank you, man.
All right, court's going to call People versus Jacob Rosbach. This is 25M4918. That case number again is 25M4918. Mr. Rosbach, in this matter, I did review the affidavit for warrantless arrest, and I did find probable cause for your arrest. So I'm going to appoint the public defenders to represent you while you are in custody. Mr. Rosbach, we need to address your bond, and we need to get you a new court date. In this matter, the district attorney has stipulated to a personal recognizance bond for you. So I'm going to set your bond in the amount of $1,500 personal recognizance with SRP and monitored sobriety. Mr. Rosbach, that means you should be getting released as to this case today. Your next court date, Mr. Rosbach, is going to be October 3rd in the First Appearance Center for an arraignment at 1:30. That is October 3rd, 1:30, First Appearance Center.
All right, sir.
All right, I've got two cases for John Qualls. People versus John Qualls.
Good morning.
Mr. Qualls, good morning, sir. You've got two matters that we need to talk about. You've got 25M4911 and you've got 29M4912. In both of these matters, the court did review the affidavit for probable cause. The court did find probable cause for your arrest. So I will appoint the public defenders to represent you in both of these matters for the purposes of bond today. Sir, in both of these matters, we need to issue mandatory protection orders. We need to address your bond, and we need to get you new court dates. In both of these matters, I'm going to issue a mandatory protection order. In both of these matters, the protected party will be Ryan Mitchell with the date of birth that's listed on the pretrial services report. In both of these matters, the protection order is governed by Brady. In both of these matters, I'm going to check boxes 1 through 7. In both of these matters, I am going to authorize a civil assist. Mr. Qualls, what this means is that you may not have any contact whatsoever with Mr. Mitchell. You must vacate his home and stay away from any place that he is likely to be found. You shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or the victim of the act you are charged with committing. Additionally, you may not possess, purchase, or control a firearm or any other weapon or any ammunition, and if you have any of those things, you must relinquish them to the appropriate authority within 24 hours of your release and then file proof of relinquishment within 7 days after that. Additionally, you may not possess or consume any alcoholic beverages or controlled substances without a valid prescription while these protection orders are in effect. I am authorizing a civil assist for you to get any undisputed personal property out of the home of Mr. Mitchell. You'll have to schedule that with the Sheriff's Department when you get out of custody on these matters. You may not go over to Mr. Mitchell's home without a sheriff's officer present. Mr. Qualls' violation of these protection orders could result in additional felony charges of witness tampering or witness intimidation or violation of a protection order. So don't violate the protection orders. All right, we need to address your bond and we need to get you a new court date. Mr. Qualls, the district attorney has stipulated 2 personal recognizance bonds for you. So in both cases, I'm going to set your bond at $2,500 personal recognizance, which means you should be getting released as to these cases today, sir. Your next court date will be September 8th in both matters, September 18th at 1:30 in Division R. That court date again is September 18th for an arraignment, Division R, 1:30.
Thank you, Mr. Qualls.
All right, let's head over to Clayton County, Georgia, where first appearances are going on. We know in Clayton County that justice is best served in a hallway, and they've got quite the lineup yet again. They stay busy in Clayton County. As well, it looks like they've had a uniform upgrade there. Those are, that's new prison orange, so let's see what's going on.
Tribunal Superior para que su próxima audiencia pueda ser programada. If you are only charged with misdemeanors this morning and want to skip your preliminary hearing so that your case is transferred to state court right away, you can sign a waiver today.
Si a usted solamente se le imputa cargos por delitos menores en la mañana de hoy y usted quiere saltar su audiencia preliminar para que su caso sea transferido al tribunal estatal, inmediatamente usted puede firmar el formulario de renuncia en el día de hoy.
If you would like to waive your preliminary hearing, you can tell me that when you come up.
Y si usted quiere renunciar a tener su audiencia preliminar, usted me lo puede informar cuando usted venga ante mí.
Lastly, it has come to our attention that the families of some defendants have been contacted by individuals on the outside who claim to be employees of the jail.
Finalmente, se nos ha informado que los familiares de algunos acusados han sido contactados por individuos haciéndose pasar por empleados de la cárcel.
These individuals claim to offer a pretrial program and dismissal of all charges if a substantial fee is paid to them.
Y estos individuos les aseguran o le ofrecen un programa de resolución previa al juicio y desestimar todos los cargos si se le paga una suma sustancial.
Please note that is a scam and there is no such program.
Por favor, sepa que esto es una estafa y que un programa de esta índole no existe.
Now I'm going to swear everyone in. Please raise your right hand.
Yo los voy a juramentar a todos. Por favor, levante su mano derecha.
Do you swear or affirm that the information you're about to give to this court, as well as any information you provided on your application for court-appointed counsel, is true and correct? If so, say I do.
Jura usted y afirma que la información que usted está a punto de dar ante este tribunal, así como también la información suministrada en su solicitud para un abogado de oficio, es correcta y verdadera, y si así es, dígalo juro.
All right. And deputies, can you guys assemble all of the fugitives for me? So, in deputies, I believe I have 7 today.
Yes, Your Honor. We're waiting.
So I need all 7.
Yes, Your Honor.
Uh-huh.
Understand, I'm still holding jail time over your head. That's usually the case when they've got this many samples. Good morning, what do you got? Come on up. Waiting for his announcement.
All right, that's more silence than I like. We will come back, but let's go spend a couple of minutes in Miami-Dade while they get things sorted in Clayton County.
And then count. That's it on this case.
You're gonna say just no bond, and then we'll say here PTD, pretrial detention, so no bond, count one.
Okay, so no bond as to count one, and pretrial detention granted.
So we put in date. Did they give you any?
We do have a stay away order on that one, state?
Yes.
That is as to victims GML and RLL, or is that, let's see. Yes, that is on 9906. So, sir, I am entering a stay away order. You are to stay at least 500 feet away from victims their initials are GML, RLL, and WA. You are to stay at least 500 feet away from these victims, the victim's homes, place of employment, or school. Do you understand, sir?
Yes, ma'am.
Right. Now, as to the third case ending in 9888, you are charged with, again, providing false verification to a pawnbroker and dealing in stolen property.
On that case, 5,000 each is fine, like the previous case.
I do find probable cause as to counts 1 and 2, and I am setting bond at $5,000 each count. With regards to that case, there's no stay away order. So again, $5,000 as to count 1 and $5,000 as to count 2 for bond. And finally, as to case ending in 9897, sir, you are charged with a first-degree felony of armed robbery with a firearm or deadly weapon, and a third-degree felony of providing or using personal or identification fraudulently. So, sir, I am reviewing the A form. I do find probable cause as to count 1 and 2.
So the state did file a motion
Just
for
5 counts of the
Right, pretrial
second charge.
I'm sorry, I apologize. There is 1 count of armed robbery and 5 counts of providing or using personal identification fraudulently.
The state did file a motion for pretrial detention requesting that the defendant be held without bond pending the hearing on count 1. On the other counts, maybe 1,500 each.
So the court is going to go ahead and grant PTD no bond as to count 1. Find probable cause as to counts 1 and counts 2 through 6, and set a bond of $1,500 for counts 2 through 6 of $1,500 each.
Get situated here.
There is also a stay away order, sir, that I am entering. That stay away order orders you to stay away from the alleged victim, Austin Mahone, at least 500 feet away from the victim's home, and or place of employment and school. You are not to contact Mr. Mahone in person, in writing, by telephone, or by social media. Do you understand, sir? Is that a yes?
So yes, ma'am.
All right, thank you so much. Have a great day and best of luck to you.
And I guess we need to go to breakout. We were having, thank you very much for,
We'll need the Spanish interpreter next, please.
Right, next up, I have Yucesley Miranda Esperde.
Yucesley Miranda.
Sí, sí.
What was the second last name, Your Honor?
Miranda Esperde.
Esperde Miranda.
Yes.
Esperde.
Esperde.
Ujú.
All
Esperde
right,
es el apellido.
Mr. Miranda,
Señor Miranda.
you're here because you have been charged with a second-degree felony for possession of a controlled substance with intent to distribute, as well as
Señor, usted tiene una acusación. Es un delito mayor en segundo grado, posesión de sustancia regulada con intento de distribuirla.
and the first count is as to cocaine, and the second count is a second-degree felony of controlled substance possession believed to be crystal meth.
Y esto es en cuanto al primer cargo, es cocaína, y el segundo es posesión de meta de cristal.
Should just be probable cause, Judge, for possession of cocaine and possession of crystal meth. No intent.
And then it would be an ROR on count number 3.
Ok, dice la defensora de que si se considera posesión de cocaína, cristal de cocaína sin intento, y la fiscalía ha indicado que se le deje libre para salir libre bajo palabra en el número 3.
All right, one moment, please.
Un momento, por favor.
All right, I do see that there's a felony, an open felony F-24-10311 before Judge Young.
Sí veo que todavía tenemos un caso pendiente, delito mayor, delante del juez Young, F24-10311.
So, would you object to a dollar bond state
Fiscalía
on count 3?
se opone al tercer cargo a una fianza de $1. Está bien.
Would Your Honor set the standard on 1 and 2, which is $2,500?
Yes, it would be a $2,500 bond with a felony hold as to case F-24-10311 and a dollar bond on count 3.
One moment, Your Honor. What was the first one that you said? $25.
Count 1 is $2,500, count 2 is $2,500, count 3 is $1, and a felony hold F-24-10311.
10311. Okay. Thank you. Para el primer cargo, la fianza es $2,500. Segundo cargo, $2,500. Tercero, una fianza de $1 porque hay una detención por un delito mayor y pendiente. Y por el tercero que termina en 103. Y este es el 10311.
All right. Best of luck to you, sir. Have a great day. Next up, I have Daniel Gerardo Torres.
We can go ahead and go back to Clayton County now. It looks like they got stuff sorted and they're actually doing business there.
Waive extradition, which means you are giving them permission to come and get you.
Cuando nosotros hablemos, yo le voy a preguntar si usted quiere renunciar al proceso de extradición, y lo que esto significa es que usted le está dando permiso a ellos para que vengan a buscarlo.
or whether you want to contest extradition, which is where you are taking the legal position that they should not have the right to come and get you.
O si usted quiere impugnar el proceso de extradición, lo que esto significa es que usted ha tomado una posición legal donde usted dice o alega que ellos no tienen el derecho de venir a buscar.
All of the rights that I explained to everyone earlier apply to you.
Todos los derechos que le enuncié al resto anteriormente les aplican a usted.
You have the right to be represented by an attorney, and one can be appointed to represent you if you qualify.
Usted tiene el derecho de ser representado por un abogado y uno le podría ser asignado si usted cumple con los requisitos.
You have the right to consult with an attorney in deciding whether to waive or contest extradition.
Usted tiene el derecho a consultar con un abogado para poder decidir si renuncia al proceso de extradición o si va a impugnar el proceso de extradición.
In order to contest extradition, you must file or have filed on your behalf a writ of habeas corpus.
Para usted poder impugnar el proceso de extradición, usted tiene que presentar o hacer presentar de su parte lo que se llama un escrito de habeas corpus.
That is the legal document or legal instrument that contests whether an extradition would be legal.
Este es el documento legal o el instrumento legal que puede impugnar o decidir si la extradición es legal.
You would be allowed a reasonable amount of time to file a writ.
A usted se le va a dar tiempo suficiente para que pueda presentar el escrito de habeas corpus.
However, the writ of habeas corpus can only contest 4 issues.
Sin embargo, el escrito de habeas corpus solamente puede impugnar 4 cosas.
The first is whether the extradition documents are in order on their face.
El primero es si los documentos de extradición aparentemente están en regla.
The second is whether you are charged with something that is a crime in the state that is seeking you.
Lo segundo es si a usted se le imputa un delito, el cual existe en el estado que lo está solicitando.
The third is whether you are the person named in that state's request for extradition.
El tercero es si usted es la persona que está siendo nombrada en la petición que el Estado está pidiendo.
And the fourth is whether you are a fugitive.
Y lo cuarto es si usted es prófugo.
You cannot contest the issue of your guilt or innocence of the charges while here in Georgia.
Usted no puede impugnar o pelear si usted es culpable o inocente de estos cargos acá en el estado de Georgia.
That has to take place in the state where the charges have been brought against you.
Esto tendría que ocurrir en el estado donde usted tiene estos cargos pendientes.
Now I'm going to tell you about your time limits.
Ahora yo voy a hablar con usted de cuáles son las fechas límites.
If you are waiving extradition, then the state who is seeking you will have 30 days to come and pick you up.
Si usted está renunciando al proceso de extradición, entonces el estado que lo está solicitando tiene 30 días para venir a buscarlo.
If that state has not picked you up after 30 days, you would be released from jail.
Y si ese estado no lo ha venido a buscar después de 30 días, entonces a usted lo pondrían en libertad de la cárcel.
If you are contesting extradition and that process has not been completed after the first 30 days, you may be held for an additional 60 days while that process is being completed.
Si usted quiere impugnar el proceso de extradición y ese proceso no ha terminado, no se ha completado durante los primeros 30 días, entonces puede ser que a usted lo detengan en la cárcel por un tiempo adicional de 60 días hasta que este proceso haya terminado.
Okay, and deputies, I'm going to see our Spanish speaker now. If you can kind of swing the camera over where I can just speak with him for a moment.
Y algo así, quiero hablar con los hispanohablantes. Primero, si puede mover la cámara.
Okay, good morning, sir. Can you state your name for me?
Buenos días, señor. ¿Me podría decir su nombre?
Marco Pacheco.
Marcos Pacheco.
Okay. Let me get your paperwork.
Déjeme buscar su documentación.
Okay, Mr. Pacheco, you are wanted out of Mecklenburg County, North Carolina for aggravated assault.
Señor Pacheco, usted está siendo buscado en el condado de Mecklenburg, en Carolina del Norte, por agresión con agravante.
Do you want to waive extradition, which gives them 30 days, or do you want to contest extradition, which may take up to 90 days?
¿Quiere usted renunciar al proceso de extradición, lo cual le podría dar a ellos hasta 30 días? ¿O quiere usted impugnar el proceso de extradición, lo cual le podría dar hasta 90 días?
Hasta 30 días también.
The one with the 30 days.
Okay, so I will indicate here that you are waiving extradition.
O sea que yo voy a indicar acá que usted está renunciando al proceso de extradición.
North Carolina will have 30 days to come and pick you up.
Y Carolina del Norte tendría hasta 30 días para venir a buscarlo.
If they fail to pick you up after 30 days, then you will be released.
Y si ellos no vienen a buscarlo en esos 30 días, entonces a usted lo pondrían en libertad.
There is a waiver form there that looks like this.
Hay un formulario de renuncia allí que se ve como este.
What the waiver says is that you are giving North Carolina permission to go ahead and come and get you.
Lo que este formulario de renuncia dice es que usted le está dando permiso al estado de Carolina del Norte para que venga a buscarlo.
And you will sign that form several times in just a moment.
Y usted tendría que firmar este documento varias veces en un momento.
And those forms will be sent to me later, and I will sign them today.
Y estos documentos luego me los enviarían a mí y yo los firmaría en el día de hoy.
And that will start the 30-day clock running.
Y esto comenzaría a los 30 días.
Do you have any questions, sir?
¿Tiene usted alguna pregunta, señor?
Pues la pregunta mía es que si no me pueden venir a buscar en menos días.
My question is, can they come to get me before that?
Yes, sir. It can be any time within those 30 days.
Sí, señor. Puede ser en cualquier momento dentro de esos 30 días.
Sí, y quería hablar con mi familia porque no he hablado con mi familia, no tengo ni el PIN ni nada también.
And I would like to speak with my family because I want to speak to my family and I don't have a PIN or anything like that.
Okay. You will need to speak to the deputies in your housing area about how to do that.
Usted tiene que hablar con los alguaciles que están en su unidad para que usted pueda hacer eso.
Okay.
Okay.
Okay. Thank you, sir. Good luck to you.
Gracias, señor, y buena suerte.
We got one more Spanish speaker.
Okay. All right.
Hey, come on.
All right, well, we may come back to there later when they're not working through interpreters so much. Let's go back to Colorado, but Douglas County this time, where I believe they're doing first appearances.
On the record in 25 M2383 People versus Dustin. Reviewed the affidavit in support of warrantless arrest and found probable cause to detain Mr. Dustin. Are the people of VRE compliant on this matter?
The people are VRA compliant on this matter. With respect to the protection order, the victim has indicated that they would like electronic contact and contact in public places only. The defendant and the victim have an 8-month-old child together, and so she would still like that contact. With respect to bond, the victim has indicated that they would have no objection to a PR bond if it included monitored abstinence and stated that a civil assist would be needed.
All right, people's requests?
Yes, Your Honor, the people would be requesting, with respect to the protection order, boxes 1 through 6 and 8. I don't have any objection to electronic contact and contact in public settings at this time because it sounds like they might need contact in public settings to exchange their shared child. So I do think that that is appropriate, despite the fact I originally filed with a full box 1 through 6 and 8. With respect to bond, the people would not be objecting to a $1,000 PR bond in this case. I would note that the defendant was cooperative with officers, made a full admission, and has minimal criminal history and scores of 2 in both categories.
Thank you, Your Honor. Well, defense is asking the court for a PR bond in this matter. I would be asking for a civil assist. As indicated, they do share an 8-month-old.
Court is issuing a mandatory protection order listing Seth Richard Dustin as the restricted party. Alina Dustin is listed as the protected party. It's ordered the defendant shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim in this case. Shall vacate the home, stay away from the home, and any other location the victim or witnesses are likely to be found. Shall not contact or communicate with the victims or witnesses. Shall not possess, purchase, or control a firearm, other weapon, or any ammunition, and must relinquish those in his immediate possession and control within 24 hours and file proof of relinquishment within 7 days. He shall not take or threaten to harm any animal owned or kept by the victims or witnesses. Court will authorize 1 civil assist as well as electronic contact and contact in public places. Compliance with the mandatory protection order is a condition of bond. Any violation can result in new criminal charges or contempt charges being filed against you. Court will set a PR bond of $1,000. Conditions are the defendant may not leave the state of Colorado without permission of the court, may not commit any criminal offenses while on bond, must appear for all court dates, must comply with the terms and conditions of the mandatory protection order, and sign the protection order before his release from custody. And I'm sorry, remind me, did you say you were asking for monitored abstinence or no?
The victim was, the people were not, because after the victim made that request, I did look through the full report, but I couldn't find anywhere where substance use was involved in this incident, so the people didn't feel as though we had a basis to request it.
Thank you. I agree. I don't know that there's a basis for me to order that. This matter is set for a pretrial conference September 18th at 1:30 in Division G with Judge Fields. Anything further?
Not from the people.
No, Your Honor, thank you.
All right, who do we have up next in LPOD?
It's Mr. Brooks.
On the record in 25 CR 909, People versus Brooks. Reviewed the affidavit in support of warrantless arrest and found probable cause to detain Mr. Brooks. Court's issuing a mandatory protection order listing Artemis Jerome James Brooks as the restricted party. Nobody is listed as a protected party. It's ordered the defendant shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim in this case. Any record on MPO, Mr. Witten?
No, Your Honor, thank you.
Compliance with the mandatory protection order is a condition of bond. Any violation can result in new criminal charges or contempt charges being filed against you. People's request on bonds.
Yes, Your Honor, the people would be requesting $5,000 cash or surety bond with pretrial supervision and monitored abstinence. I do think pretrial supervision and monitored abstinence are appropriate in this case, given the charges are felony and misdemeanor drug charges of possession. I would argue that the $5,000 cash or surety bond is appropriate, given the pretrial report scores of 4 in criminal activity, and 2, in failure to appear. I would also point out that the defendant has a felony conviction within the last 5 years. So I do think $5,000 cash or surety with pretrial supervision and monitored abstinence is appropriate to address the people's community safety concerns in this case.
Mr. Witt.
Thank you, Your Honor. Your Honor, in this case, the defense is asking the court for a PR bond or in the alternative, a low cash surety bond. Your Honor, if he is to be released from custody, it's my understanding he was in the process of moving into his new apartment today. He spent most of his money with the first and last in security deposit that he had to put down for this place. Your Honor, I do note, just as the district attorney did, that he has a low failure to appear score, and it sounds like his criminal activity, while he does have that, it sounds like it's a little bit older within the last 5 years and not necessarily something that happened last year. For these reasons, Your Honor, we're asking the court for a PR bond. Thank you.
We'll set a PR bond of $1,000. The court's looking at his pretrial report. Doesn't look like he has ever failed to appear, at least in a Colorado case. I believe the monitored absence will address any other community safety concerns. Conditions are the defendant may not leave the state of Colorado without permission of the court, may not commit any criminal offenses while on bond, must appear for all court dates, must sign a waiver of extradition before his release, must comply with the terms and conditions of the mandatory protection order, and he'll be placed on pretrial supervision and monitored abstinence. The method of monitoring will be determined by pretrial services. This matter is set for filing of charges September 17th at 8:55 in FAC if in custody, or October 14th at 11 a.m. in FAC if on bond. Anything further?
Nothing from defense.
All right, here we have up next in LPOD.
I have Kevin Johnson.
I can't get a hold of boy.
Court is on the record in 25 CR 900, People versus Kevin Johnson. Mr. Johnson's appearing on a warrant issued on affidavit September 8th. Bond was set at that time at $50,000 cash or surety. Are the people VRA compliant on this matter?
Yes, Your Honor, we are, and it is my understanding that the victim intended to address the court for self over WebEx, so she might be in the lobby. Her name is Antonia.
All right, the court has just called up the matter of Kevin Johnson, and Miss Johnson, I see that you're on the WebEx. Did you want to make a record today? Miss Johnson, can you hear me?
Yes.
Okay. Did you want to make a record today?
Yes, I can talk on his behalf, on my side of it.
Well, I'm asking you to make a record on behalf of the victims in this case.
Yes, so the victims in this case would be Kevin is a wonderful father. He's been sober since October 25th of last year. And this is all a whole situation that he's been home with the kids. This situation is traumatizing our family. He's a good dad. He is the main income of our household. He runs a successful, by the labor of his own hands, window cleaning company. We do not have employees. No, he suffers from TBI from this accident and he's in recovery. He volunteers for his children. He does baseball and football on the weekend. He's active in his home church at Jubilee. He works hard to provide for us. And without him, we will end up homeless with no family here. My family's in Montana. Thor did not get a skull fracture. He had a very minor injuries, which included just observation during the crash at the hospital. He had a mild concussion, and Kevin's the breadwinner. Kevin took this injury as a result, and he has over $28,000 in debt over the course of this injury, going into the summer months where I had to take care of the kid, working twice a week. to even keep a roof over our head. We rent. We do not own a house. We do not have property to where we can get him out. If he's in there, we're going to sink. We have $800 to our name. My children are 5 and 7. At the time this happened, they suffered enough. He was in a wheelchair for months. He broke both his arms and his leg. Thor was completely fine. Please don't do this to him. We've spent all of the year healing, and he's found God, his sobriety. He does community service. You know, he's really worked on his recovery and his faith through this. We cannot bond him out. And I do not have the means to do so. I do not have a job. I work with him, with the company. He's the one that collects the paychecks. I do not. I'm the one that schedules all the jobs for him. This bond, we can't afford it. He needs to be able to get out on something. My children have suffered enough. I lied to them about where he is. This is our only hope to survive with our children through the winter. This is going to damage the reputation, his spirit, our beautiful children. Thor, who's in 1st grade, Huntley's who's in 2nd grade. I need help to raise these children. I do not have any way of supporting them. And this is going to end up with us being on government assistance. The system is broken. This is not the way that we should be helping our people by incarcerating them and stripping away their everything and breaking their spirit. He's a good man. This house will fall without him.
Okay, thank you, ma'am. People's request on bond and MPO.
Yes, Your Honor. With respect to the protection order, the people are only asking for boxes 1 and 7 at this time. We would be asking for box 7 given that the defendant was under the influence at the time of this incident, and we would ask that the child victim be listed as a protected party in this case. With respect to bond, the people would be asking that bond remain at $50,000 cash or surety, when we would ask that as a condition of bond, the defendant be placed on pretrial supervision with a scram monitor. I would note that this would be a 4th DUI offense. There is not a 3rd conviction yet, but there is a pending 3rd as well. So with the number of pending cases as well as DUI convictions, this would be a 4th offense. I do think that $50,000 cash or surety with pretrial supervision and scram is appropriate to assure the community's and the victim's safety in this case. I would note that these 4 DUI offenses have occurred within the past 12 years, and this time the defendant not only was driving under the influence, but also had his 4-year-old child with him who did suffer serious bodily injury and did suffer a skull fracture. I understand the victim's representative, their parent, made a different record before the court today. However, the court can see in the affidavit that was filed in this case that the people did obtain, or law enforcement did obtain, a warrant for the child victim's medical records. And in those medical records, it is confirmed that a CT scan was completed of the victim's head and neck, and he was seen to have a skull fracture as well as a hemorrhage, and other injuries were noted as well. So the court is able to review that in the affidavit in this case. Additionally, not only did the defendant have his 4-year-old child with him, he got into a rollover crash involving only their one vehicle, which was actually a Polaris Ranger, which is more like an ATV open vehicle, to kind of give a picture for the court. And from the investigation, it seemed as though neither the defendant nor the child victim were properly restrained or wearing a helmet or the proper age and size to ever be riding around in a Polaris Ranger, according to the manual for the Polaris Ranger, which states that helmets, eyewear, and seatbelts should be worn at all times. None of those were worn in this case. and that it should never be operated with a passenger under the age of 12, which this child victim was in this case. I do have serious victim safety concerns given the facts of this case and somewhat the response to this case. The defendant ended up refusing a blood draw or chemical test, and officers had to get a warrant. The defendant's BAC was 0.140 at the time they decided to get into a vehicle without their 4-year-old child being restrained, and ended up rolling over and crashing the vehicle. So I do think $50,000 cash or surety with pretrial supervision and scram monitoring is appropriate in this case.
Mr. Witt.
Thank you, Your Honor. Your Honor, in this matter, it's my understanding that the date of offense is from back in 2024. Your Honor, it's my understanding that Mr. Johnson has been out on bond since 2024 and has been in compliance with bond. It's my understanding that this charge is one from as indicated from 2024. If he is to be released from custody, he would be able to continue working. I don't need to supplement the record that was made by his spouse in this matter, but he is the primary breadwinner for the home. He is the one who helps support the family. For these reasons, Your Honor, we're asking for a low cash surety bond. Thank you.
The court's reviewed the affidavit in this case as well as the pretrial services report and does note that this is potentially a fourth DUI as noted by the people. Others are from a 2024 case, 2013 case, and a 2019 case. There's also a drunk with a gun. So all of the history in this case involves alcohol abuse. It would seem from the criminal history here that alcohol is essentially the cause for all of his criminal troubles. And so restricting alcohol theoretically should address the victim safety concerns in this matter. The court's heard the record from the victim, noting that he is the primary breadwinner and the hardship it'll cause on the family. The court also knows that this warrant that was just executed does concern a 2024 case, and thus he's been parenting the children since that date. The court also notes the victim's record that he's been sober since October of 2024, which I'm delighted to hear. I hope that that is able to continue as well. So the court is going to set a PR bond of $50,000. Conditions are the defendant may not leave the state of Colorado without permission of the court, may not commit any criminal offenses while on bond, must appear for all court dates, must sign a waiver of extradition before release, must comply with the terms and conditions of the mandatory protection order. He will be placed on pretrial supervision and monitored abstinence. The method of monitoring must include scram. Court is issuing a mandatory protection order listing Kevin Ray Johnson as the restricted party. TJ is listed as the protected party. It's ordered the defendant shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim in this case, and shall not possess or consume alcohol or controlled substances without a valid prescription. This matter is set next for a preliminary hearing. Actually, before I get to that, are you waiving formal advisement on the complaint?
Yes, Your Honor.
Preliminary hearing is set for October 3rd at 9 a.m. in Division E with Judge Wadler. Is there anything further on this matter today?
No, Your Honor, thank you.
Thank you, Ms. Johnson, for being here this morning and making such a thorough record. It was very helpful.
Thank you. And I'm sorry, what was the time on October 3rd?
9 a.m. in
And-
Division E as in elephant.
Okay, 9 a.m. and he's not allowed to have he's not allowed to be in the house? Is that what you're saying?
No, he can be in the house. It's full contact is allowed.
Oh, thank God. Thank you so much. Thank you.
You're welcome. Have a nice weekend.
You too.
I got a few things. And by the way, I'm going to probably start speaking a little more than I normally do. So you'll either like that or you won't. But, you know, on the surface, you can look at this and say it's refreshing to see a wife actually supporting her husband, because spouses don't seem to support each other as they used to. And that's true, but that's on the surface. Listening to her closer, digging deeper in my brain as to what I saw there, I don't think she's worried about him as much as she's worried about herself, and the fact that she might have to go figure things out and come up with a better situation than the one that she has now. So my take on it is her statements are more selfish than they are in support of him. Second, quote, he's a good man. Really? It amazes me how often we watch these courts and we hear statements like that this is a good person. I can understand that if it was their first time in court, because all of us stumble and fall. And I've said it so many times to all of you that any of us with a couple of missteps, a bad day, can end up in front of one of these judges. And I mean that. It's true. We could. So I don't necessarily fault a person if that happens. But what were we on? A fourth DUI? The third one's still pending. Endangerment, all of these things. At one point he was drunk with a gun. This is not a good man. So the idea of defining him in that way just racks my brain, breaks my brain. I don't get it. These are the things that we need to figure out if we're going to be a better society. End rant. Let's go back here for a few more minutes and then we'll probably go to dungeon court after.
Am I gonna get a PR bond?
Yes, you got a PR bond. Did you hear the conditions that the court just went through?
Sí, que debo presentarme a todas las cortes.
I want to go to court.
Was he advised this morning? I just want to make sure.
Yes, yes, he was.
It's mine. Yes, Your Honor, I do show.
No, he doesn't seem to understand what's going on, and I'm not sure if he's hearing everything okay. Are you hearing everything the interpreter is saying okay?
Sí, dígame.
Yes.
Sí, pero no lo entendí mucho porque hay mucha bulla alrededor suyo.
Yeah, but I didn't understand very well.
Okay. So let me go through the conditions of bond one more time.
Your Honor, an interpreter is gonna get off the headphones and see if that will help.
Okay.
Sí, sí.
All right, conditions of your bond are that you may not leave the state of Colorado without permission of the court. You may not
Okay.
commit any criminal offenses while you're on bond. You must appear for all court dates.
Okay.
And you may not drive without a valid
Okay.
license and insurance.
Ok. Sí, entiendo, entiendo.
All right, your next court date is set for October 13th at 8 a.m. if you're on bond.
October, what is that?
13th at 8 a.m. if you're on bond.
Ok,
If
13
you're
de
still in
octubre.
custody, you'll be appearing at 1:30 that day. Anything further from the people?
No, Your Honor.
Mr. Witt.
Nothing from defense. Thank you.
All right, that will conclude Mr. Rodriguez's case today. Thank you, Ms. Rubon. Oh, there is. Okay. Jonathan Guzman? What? Report is on the record in 25M 2099 and 25T. Can't read this case number. Hold on. 1325. Thank you. 25T 1325. All right, I have here two plea agreements. One plea agreement indicates you're pleading guilty to one count of no proof of insurance, and you've agreed to a $500 fine. The other one is that you have agreed to plead guilty to one count of theft with a sentence of 2 days jail and 2 days credit for time served.
Yeah, I was there today.
Is that your understanding?
So they gave me the offer of or either pay the fine or going 2 days to jail. But since I had the 2 days, then right here, the paper showing that I was detained 2 days is here.
Right, that's what I'm seeing. And Ms. Slaughter, there's a restitution language in the theft plea of 25M 2099. Is that a typo?
I'll take a look. Yes, I believe that was a typo.
Okay, so I'm going to ask the DA to refile. Sir, are you entering into these agreements voluntarily? I need an audible yes or no.
Yes.
Has anybody threatened or coerced or forced you to enter into these agreements today?
No.
Are you under the influence of any drugs or alcohol that would affect your ability to think clearly?
Oh, nothing like that.
Do you believe you understand the elements and possible penalties for these charges?
But I do understand.
Are you aware that 4 points will be assessed against your driving privilege?
Yes, I am familiar with that.
Would you agree these charges are based on something that you did? Did you do these things that you're pleading guilty to?
Yes, please.
And are you aware of the rights that you're giving up with this plea agreement, including the right to take this to trial and to be represented by a lawyer? How do you plead to one count of no proof of insurance, guilty or not guilty? How do you plead to one count of theft, guilty or not guilty? Finds your plea has been entered voluntarily with an understanding of your rights, the nature of the offense, and the possible penalties, and accepts your guilty plea. Did you want to make any statement regarding the sentencing of either case today?
Hello. Thank you.
Well, thank you very much for that. I really appreciate that sincere apology. We'll accept your sentence agreements. Sentence you to a $500 fine plus court costs and fees. And sentence you to 2 days jail with 2 days credit for time served. Court waives any fines in that case, but orders court costs and fees. No restitution is ordered in either case. That will resolve these matters today. Don't leave the courtroom before we give you your final sentencing order in each case. Don't leave until we give you your final sentencing order, and then you can go. All right, thank you.
Okay, friends, it's Friday. It's that time. You know, there's a lot of different ways that you can serve justice. As we know, in Clayton County, you can serve it in a hallway. In Kentucky, you can serve it in what appears to be a converted library. But then there's Southern Ohio, where you serve it in a dank, dark, converted dungeon with Cold War lighting, carpet ripped straight from the set of The Shining, a punishment chair in the corner, the souls of the dead screaming from behind the camera, horrible production quality, a cast of characters that's unmatched. Ladies and gentlemen, I present to you our guilty pleasure here at TCF for your enjoyment. It's Dungeon Court.
Most nicely, it's alleged that on or about, well, we need Mr. Hill in the courtroom. Mr. Hill, this is State of Ohio versus Christian Nicely, COD 25567. On the complaint, there's not a date of offense on this. It just says September.
Okay. I'll have to
and if you want an opportunity to look into that, I would certainly give that to you before we do the grant.
Okay, we'll do that.
All right, we're going to recall this in a few minutes.
Yes, sir.
Have a seat in the back.
Okay.
State of Ohio versus Shelby Frazier, case number TRC 252357, A, B, and C.
So the State of Ohio versus Shelby Frazier, TRC 252357, A, B, and C. Ms. Frazier, it's alleged that on or about September the 9th, 2025 in Perry Township, that you are operating a motor vehicle while under the influence of alcohol, drug abuse, or a combination thereof. That's an alleged violation of Ohio Revised Code 4511.19A1A. That is a first-degree misdemeanor. The maximum penalty on that's up to 180 days in the Lawrence County Jail, up to a $1,375 fine, up to a 3-year license suspension. On it, the minimum penalty on that is either 3 days in jail or 3 days at a driver intervention program, a $575 fine, and a 1-year license suspension. You're also charged with, under Ohio Revised Code 4511.21D1, speeding. It's alleged 69 miles per hour in a 55 mile per hour zone. That is a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. And that you are operating a motor vehicle on expired tags. That's an alleged violation of Ohio Revised Code 4503.11. That's also a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. How do you wish to plead?
Not guilty.
All right, I accept you're not guilty plea. See, all right. I'm going to let you sign a $1,000 signature bond, which means you're being released on your own recognizance. You don't have to pay anything, but if you don't show up to court, the court can forfeit that bond and make you pay $1,000.
Your Honor, does she need to be?
Yes. Thank you. I'm going to order that you be fingerprinted. You'll have to report to the jail to have that happen. They'll fingerprint you.
Don't leave, I'll meet you out in the lobby. I'll bring you copies.
Can you, do you have an attorney?
No.
Do you wish to be considered for court-appointed counsel?
Yes.
Okay. Are you working currently?
Not at the moment, no.
Okay. I'll find you qualified. I'll appoint Attorney Luke Steyer to represent you. This is an OBI with a urine screen, Mr. Steyer.
Okay.
When would you suggest we come back for a pretrial?
I think the neighborhood of 6 weeks would be appropriate. Is Monday or Friday better for you? Okay. Well, as of right now, would the 20th work?
October?
Yeah, the Friday's in October. We're mostly taking up my jury trials right now.
20th would be fine.
Okay. So write that down, October 20th, 10 a.m. Were you taken to the sheriff's department? Were you fingerprinted?
No.
Okay. She was not fingerprinted, so.
I did.
Oh, you already had that discussion? Okay.
I'm ordering her to the jail. To be
Okay.
fingerprinted and start using the copy
I
of the
did
file.
renew my tax.
Did you ever sign a bond already?
Yes. Yeah.
Okay, perfect. I'll come out and tell you in the lobby. Thank you.
State of Ohio versus Joshua Brad, case number PRB 252358, A and B.
The State of Ohio versus Joshua Pratt, TRD 252358A and B. Mr. Pratt, it's alleged on or about September 11th, 2025, in Rome Township that you were operating a motor vehicle while speeding. It's alleged 77 miles per hour in a 55 mile per hour zone. That's an alleged violation of Ohio Revised Code 4511.21D1. That is a minor misdemeanor. Maximum penalty is up to $150 fine and costs. It's also alleged you were operating a motor vehicle on fictitious plates. That is an alleged violation of Ohio Revised Code 4549.08. That is a first-degree misdemeanor. Maximum penalty is up to 180 days in jail and up to $1,000 fine. How do you wish to plead?
Guilty.
All right. Are you sure you want to enter a guilty plea on this?
I guess.
Okay.
Is it all true?
All right. On the speed offense, it's going to be, I'll accept your guilty plea and a guilty finding. It's going to be a $100 fine. On the fictitious plates, it'll be 10 days in jail. I'll suspend all 10 days. It'll be a $50 fine.
I'm sorry,
$50 fine. And I will repay the court costs. And it'll be one court cost.
You want the March 20th, 2026 review date?
Review March 20th for review, and I'm going to put you on 2 years level 4 probation. So before you go, you're going to need to meet with probation and see the clerk.
Your Honor, if he has to prove the insurance, you can show that to the clerk also. It's more than the insurance.
Okay. If your ticket is marked that you don't have insurance, if you have insurance, if you can show it to the clerk today, we can send it in with insurance. It'll save you a lot of headache dealing with the B&B. If not, if you don't have that to us today, you'll have to show it, go through the B&B to do that, and that is going to be a significant amount of work because they may suspend you for.
I got insurance.
Okay. So if you would, you're going to need to show that to the clerk today.
All right.
Okay? All right. Thank you.
You're welcome.
State of Ohio versus Anthony Giamarco, case number CRD 24724.
This is State of Ohio versus Anthony P. Giamarco, CRD 24724. Mr. Giamarco is present here this morning. It looks like this is an arraignment on a failure to appear for a review hearing on September 2nd of 2025.
Yes, sir.
Mr. Giamarco, do you admit or deny that you failed to appear?
I admit it, sir. I was real sick. I couldn't make it.
Okay. I will recall the warrant.
Your Honor, if I may, he was at community service yesterday. I don't know if this folder will be updated emergency arraignment.
Okay. I've got 6 hours from the last time he was here, so an additional 3. So looks like you're down to, if that's the case, 9 hours of community service and then the treatment's all you've got left.
Yes, sir.
So I'm going to set you back October 31st for review at 9 a.m.
Okay. Thank you, sir.
All right. Thank you.
State of Ohio versus Judith Napier, case number TRC 222747.
This is case number TRC 222747, State of Ohio versus Judith Napier. Looks like this is also a failure to appear for an arraignment back in 2022. And a treatment update from Southern Code. Ms. Napier, do you admit or deny that you failed to appear for your arraignment?
Yes, sir, I admit it. I was to be really, really bad off on drugs. I'm not even gonna lie.
I will order the warrant to be recalled, and we'll go ahead and do your arraignment. All right, Ms. Napier, it's alleged on or about December the 11th of 2022 in Fayette Township that you were operating a motor vehicle while under the influence of alcohol, drug abuse, or a combination thereof, and that you refused a chemical test. That's an alleged violation of Ohio Revised Code 4511-19A1A. That is a misdemeanor of the first degree. Maximum penalty on that is up to 180 days in jail, a $1,075 fine, and up to a 3-year license suspension. Minimum penalty on that is minimum penalty on that is 3 days jail or 3 days in a driver intervention program, a $375 fine, and up to a 1-year license suspension. How do you wish to plead?
Not guilty.
Okay, I will accept your not guilty plea. I'm going to let you sign a $1,000 signature bond, and as a condition of your bond, you're going to have to continue your treatment as a condition of your bond.
Yes, sir.
I'm going to order that you be fingerprinted. So you'll have to go to the jail to do that.
Don't leave, I'll come out and give you a copy of this. Okay.
Do you have the money to hire an attorney?
No, sir.
Are you working currently?
No, sir.
All right. I will find you qualified for appointed counsel. I'll appoint Attorney Roger Smith to represent you. Mr. Smith, this is a 2022 ODI and a refusal. When would you like to substitute on that?
Judge, I'm starting to, next time I'm here is the 17th of October. I'm here the 14th, I've already got like 14 cases that day.
We can add you on the 17th.
And I will waive time, Judge. I'm trying to file discovery.
Fine, Mr. Smith to waive time on behalf of his client, and we'll set this for October 17th at 10 a.m. for pre-trial.
Thank you, Judge.
Thank you, Mr. Smith.
I'll come up, just say no, I'll come up. Just wait for me up there.
Am I done?
Yeah.
Okay, thank you.
Thank you.
State of Ohio versus Brittany Tolbert, case number CRB 23767.
This is State of Ohio versus Brittany Tolbert, CRB 23767. Ms. Tolbert's now present here this morning. Looks like this is a failure to appear on the review hearing on October 24th, 2024. Ms. Tolbert, do you admit or deny that you failed to appear for your review hearing?
I admit it.
Okay. You got a good reason why you weren't here?
I had stated in court, sorry, I'm sick, but I had stated in court where I worked when I was here, and someone had called my job and got me fired. I'm not saying it was from the courthouse, but I got fired like the next week from my job, so it took me a while to get back into the workforce.
Okay. Are you presently working?
Yes.
I'll recall the warrant.
I paid all my fines in full.
Okay.
Ms. Tolbert wasn't arrested on the warrant, was she?
She wasn't.
No, I just come in today on my own.
All right, I'm going to go ahead then and close your case. Looks like everything is paid off and taken care of.
Thank you.
All right,
Have a good day.
You too. Actually,
Start pre-trials, Your Honor.
all right. Need pre-trials in the courtroom.
State of Ohio versus Travis Grimm, case number TRC 251798, A and B.
This is State of Ohio versus Travis Grimm, here at 251798 A and B. Mr. Grimm's present, and Mr. Peaches, case represented by Mayor 17.
Your Honor, I believe we have this case resolved pending your approval. I believe we would ask the court to amend one of the OVI charges to a minor misdemeanor, reckless driving, dismiss the other charge, Your Honor. The defendant would withdraw his ALS appeal and suffer the remainder of the administrative license suspension. I expect the state to agree to return the firearm. I will tender an entry to the court in the future. I believe that's it.
And we have agreed to do that, Your Honor, and it's based on a number of evidentiary issues that we feel will probably make it a little more difficult for us to prove the case, and we think this is an appropriate outcome.
And Your Honor, he's prepared to pay the fine and costs imposed today.
Okay. We also have, I didn't call this one, the CRA 25-452. So I want to make sure I've got that correct. We've got the OVI, the improper handling, and the speed offense. The OVI, what are we doing to Mr. Hill?
That's going to be amended to the reckless.
Okay.
The gun charge, here, what is revealed by the video is that Mr. Grimm did have possession of the firearm, and when the officer approached him initially, when he first approached the vehicle, Mr. Grimm reported that to the officer before anything else was said. So we felt like he acted responsibly, even though we probably should have had it with him under the circumstances. So we're okay if it would be referred through him, and we don't intend to pursue that charge further.
Okay. All right, so you're going to make that amendment, I presume you're not then nolling
That's correct.
The CRA case?
Yes, Your Honor.
All right. All right, that leaves we've got the amended charge and the speed offense.
I expect the speed to be dismissed, Your Honor.
Okay, is that correct, Mr. Hill?
Yes, Your Honor.
All right, so we'll dismiss the speed offense as well. All right, on the A case, which is the remaining portion, it'll be a $150 fine, and all of the court costs will be paid. And all that's paid today, which I should include the intention of that, there won't be probation.
Thank you, Your Honor.
And I'll approve that there'll be an entry to return the firearm. You'll continue that entry.
Yes, sir.
Thank you.
I'll be right out.
State of Ohio versus Presley Gore, case number PRC 25-1946, A and B. Mark, I'm going to have something to do with what do you about
This is State of Ohio versus Preston Gore.
Your Honor, the officer is correct. It's Presley Gore. My staff made a mistake by referring to him as Preston Gore in all of my filings.
Okay. And this is for a motion for limited driving privileges.
Your Honor, if I could ask the court, the 2255 form, both the original in my possession and the one that I received in discovery, indicates that Mr. Gore was not placed under an administrative license suspension. So that may not be an issue, Your Honor. But, Your Honor, Mr. Hield and I pre-trialed this case today. We're working through some discovery issues. I have until Monday to be timely in a motion to suppress, which I will have filed. I would ask the court to allow us to come back and pre-trial the motion once it's filed, and then we can schedule from there. I'm here, Your Honor, on October 3rd and October 10th, if either of those dates are acceptable.
I know we're trying to keep October 3rd, why do you choose that?
Okay, we'll do October 10th now.
No, that's fine.
All right, I'll set it for October the 10th for pretrial at 10 a.m. at the defendant's request.
No. 10:10, you say, Your Honor?
10:10. 10:10 at 10.
Your Honor, since we're going to pre-trial the motions on that date, my client works full-time. I believe Mr. Heald would agree to excuse his presence at that hearing if the court is agreeable.
All right. On the file that Mr. Gore's appearance will be excused for that.
Thank you, Your Honor.
Thank you, Mr. Reeves.
Alrighty, my friends, it unfortunately is that time. It is time to say goodbye. But thank you for today. I've made no secret that this week has really been not one of the greatest for me. Just with current events and things that went on. But I needed a good day today, and you guys gave it to me, and I really appreciate that, so thank you. I will be back tomorrow night for game night. That's 8 p.m. Eastern, 5 p.m. Pacific. I imagine we'll continue with Lego Star Wars, since that's what we've been doing. So if you haven't joined us for that before, feel free. We don't talk court. We just hang out, and you get to watch a 50-some-year-old guy do mediocre gaming. It's just outstanding. Some of the best programming out there. So give that a look. And then we'll be back Monday, obviously, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. For those of you who are new channel members, please join us. You'll love the pre-show. It has a great format. The format is there's no format, so it's like perfect. But yeah. Go have yourselves a great Friday and a great weekend. I look forward to seeing you all, if not tomorrow night for game night on Monday. But in the meantime, take care. God bless.